Welcome to our webinar for today. My name is Erica, and I'm going to be your host. Thank you for joining us. The focus of the webinar is migration, visas, and your business. So this is an employers only webinar. We are focusing on employers in Australia and how visas and the recent changes in terms of employer visas for overseas workers, how this is as a whole affecting your business, the business you own, the business you work for, and how things are going to look going forward. We are a migration firm, we are a law firm, we've been in the market for 15 years, and we've been assisting businesses secure employer sponsored visas. So some of these visas might be famous. You may have heard of the famous 457 visa. It's been replaced by the TSS 482 sponsorship still visa. We like to say that visa changed its clothes, but it's the same person in the end, just a change of name. Mainly the requirements are the same. Some of you, we might have helped with subclass 400, which is a short activity visa for people who are overseas and they have a project short term, as the name says. So they come for a one-off project or a short 3-month stint. Nothing prevents these people from staying and applying for other visas. But initially, this is a visa where Australian employers source talent and skills for one-off, non-ongoing projects in Australia. We also have the training visa 407, which has always existed, but it used to take so long to be approved that it became unviable for many employers out there. Thankfully, we've seen a big change in processing times. And now, with some of the changes that will apply to the subclass 482, this may be a good option for employers who are not in a position to nominate their workers for the 482 visa. We're going to touch on that. We've also helped employers all over Australia with the permanent employer nomination visa subclass 186. And the majority of people who come to Australia on a temporary visa, who are working for your business on a temporary visa, they will most likely, in their majority, I don't want to generalize here, but in most cases, this is what happens. A lot of the temporary visa holders start working in Australia, enjoy life here, enjoy the work culture and the lifestyle, and they want to remain in Australia permanently after working for a few years. So this visa has, in one form or another, also existed for a long time. It has been dramatically restricted by the previous government. The coalition government really made it hard for the majority of workers out there on temporary visa to apply for and be granted this visa, to the point that it is for only a few occupations at the moment. With the changing government, the Labour Party has always been very vocal in terms of what they believe this visa's role is in the whole skilled migration program. They believe that if we invite skilled workers to come to Australia and work here on a temporary visa, such as the 482, the training visa, even a 400 visa, that if that skilled worker, if they so wish to stay here for longer than their temporary visas, that there should be permanent visa pathway for those people. And one of the changes we're going to discuss today involves this visa, the 186, and how it's going to be expanded in terms of eligibility. A bigger number of people will be able to apply for this visa, which is great news for workers, but for employers as well. And we're going to discuss why. We also have a regional sponsorship visa, subclass 494. This visa is newish. It has existed since November 2019. and it has replaced what used to be called the Regional Migration Scheme, Regional Visa 187, which was a permanent visa. But unfortunately, that visa was abused by employees and employers alike, to the point that the government decided to create a two-step visa. So some regional employers get some flexibility when sponsoring workers because of the difficulties regional employers encounter, which are even more than employers in larger cities. But the employee has to stay on that visa for at least 3 years before they can apply for a permanent visa. So this was a mechanism the government has devised to actually ensure that the program and this visa are not so badly abused as was the case in the past. As you can tell by my accent, I am a migrant myself, and I registered as a migration agent in 2005 and co-founded Bravo in 2008. So if I stop and count, I probably worked on more than 10,000 visa applications if I count before Bravo and as part of Bravo. I'm also an assessor for the capstone exam. This is the entry level exam for anyone who wants to become a migration agent in Australia. And I present webinars just like this to other migration agents who need to renew their licenses every year. I've been in Australia since 96, and I've always been working with international students, international workers in one way or another since then. And since then, not a lot has changed in terms of skills shortage. I've been talking about skills shortage like a broken record for over 2 decades. And this is not a new thing. There's it's not something no one has ever talked about. It's, as I mentioned here, it's enshrined in our labor market. It's always been a given. We don't have enough skilled people to fill all skilled vacancies out there. And with time, we also seen sometimes there's not enough people to fill the non-skilled positions out there as well. As we saw during COVID and the borders being closed, we rely a lot on temporary visa holders, such as students, backpackers on working holiday visas. We relied on them for many years when it came to those low-skilled jobs, and we really felt the impact of not having new temporary visa holders coming into the country during the pandemic as the government closed the borders for almost 2 years. So there's nothing new, right? However, since the pandemic, things started getting worse. I'm not even going to talk about low skilled positions or non-skilled positions. What we're focusing here today is your business and the positions that can be sponsored, the positions that are skilled positions and that you most certainly are struggling to fill from the local labor market. So it's always been a common thing for Australian employers to end up relying on international workers. Even employers who may never sponsored someone, who may never really have facilitated a visa for someone to work in their business, chances are that if that business has been around for a while, that they may have hired someone on the temporary visa one way or another. So we see lots of businesses, as I mentioned, relying on international students who, for a long time, could only work part-time. And at the moment can work full-time because of the skills shortage. And we're going to talk about that soon. Or may have employed a working holiday visa holder. And a lot of people think backpackers come to Australia to work in the farms and have a holiday and then go home. But the reality is there's a lot of backpackers, the countries that provide us with working holiday makers, the countries with which Australia has an agreement in terms of working holiday visas, are normally countries where people are skilled. So we see a lot of tradespeople coming from the UK, including Ireland. We see a lot of IT and marketing people coming from the US. They can also get a working holiday visa. Lots of hospitality workers from Canada, because Canada has a huge hospitality scene as well. So, in a lot of cases, businesses end up hiring these temporary visa holders. They might work for that business for a while and then they might go home or the employment ends. But in a lot of cases, businesses end up having to at least try to find a way of keeping those temporary visa holders with them. And if that person or persons have a visa expiring, then they get in touch with a company like Bravo to look into options. And that's where we come in and start discussing what is possible and not possible, not only from that employer's perspective, but we also need uh, um, we need to look into what that person can do, what that person has in terms of skills, and what visa do they meet the requirements for. So um, a lot of employers, if they haven't already hired an international student or a working holiday visa holder once, sooner or later they will end up having to. But there's a lot of employers out there who have already sponsored workers for longer periods of time, who may then have nominated them for permanent residence, and might have developed a reliance on these temporary visa holders who are already in the country to fill their gaps in terms of skills. We have some clients who actually have to go a further step and start recruiting directly from overseas. So some of our clients, in terms of trades, companies providing trade services, sometimes they have to do recruitment drives in the US, in the UK, in South Africa, and we have to bring workers directly into the country already on one of those visas where we have discussed things and the like. The reality is that there is a skills recession and it's not looming, it's here upon us now. And if your business hasn't had to rely on temporary visa holders who are already in the country and employ them on those visas, um, it might happen sooner or later. And if you're not an employer who's already been sponsoring, um, it might be an option for you as well. So I have some stats for you. I'm not saying these things to you just because that's my opinion or the opinion of our business or what we see out there. What We do a lot of research to see where the market's going, see what our clients will be needing in the short and long term, and we see a lot of and we do a lot of studies, and we're very interested in statistics, mainly to guide where we are going and to see what the industry and the sectors will be needing, but also to discuss with our clients who are employers. And when they say, I'm experiencing this or that, we say, you're not alone, or yes, this is very unusual. So our latest information that I have to share with you came from the Hayes Recruitment Salary Guide. They have released this probably 2 weeks ago, and it's the guide that talks about salaries and how much people should be earning in which sector and so on. But I'm always keep an eye out for this guide every year, because they interview businesses in Australia and New Zealand every time they release the guide. And they always talk about what employers are experiencing and skills shortages, and sometimes they talk about sponsorship visas, which was the case this year. So this whole skills recession is not a term I have coined, it's a term they are using. And they're saying that even though the skills shortage is a common thing in our labor market, it is intensifying, and they believe it's going to be a problem for the next few years ahead. The top 5 industries that are experiencing the worst shortages are in front of you: construction, technology, manufacturing and operations, accountancy and finance, and healthcare. 88% of 6,000 business surveyed have declared in the survey that they are experiencing skills shortages. 40% of these guys say that it has intensified in the last 12 months. So again, Hayes is also not just theorizing here. They're basing what they're saying that there's a skills recession and that it is intensifying on this data. Now, what matters to us here today is that from the 6,000 businesses that they surveyed, 37% would consider employing or sponsoring an overseas worker. And another 32% on top of this would be open to this possibility. So 69% of the 6,000 businesses are having to think about, in one form or another, they're having to think about overseas workers. And not only we want to keep our clients, our current business and employer clients updated, reason why this webinar is happening, but we think, okay, if there's at least 69% of business thinking about sponsoring people, these employers must be craving information. And one of our missions as a business is to provide accurate and easy to understand migration information. So here we are today. Now, if you are one of these businesses that are considering employing or sponsoring an overseas candidate, or if you are one of the employers who already works with us or who is already sponsoring people, you may know about some of these things I'm going to cover here, but it's always good to really have a look at the basics. Now, if you are an Australian-born person, you never have thought about a visa in your life for yourself or for a family member because you don't need a visa. What is a visa? A visa is a travel document that allows someone to enter and or remain in Australia. We have visas that have an expiry date, and that's temporary visa. And we have visas that do not have an expiry date, and that's a permanent visa. Now, this is different from being an Australian citizen. Someone can only become an Australian citizen after they have first obtained permanent visa, permanent residence. Unless you're a New Zealand citizen, the government just announced some direct pathways from the temporary New Zealand citizen visa that every New Zealand citizen is granted when they come to Australia. It will be now possible to go from that straight to becoming an Australian citizen. But for anyone else, you first have to become a permanent visa. So we're not going to be talking about citizenship here because as employers, this is none of your interest. As an employer, you need to think, okay, I want to hire this person. First and foremost, does this person have a valid visa? And this, if you are considering sponsoring someone or not, is a question that has to always be in your mind. If you employ someone and they are not an Australian citizen by birth, you should be asking them, what kind of visa do they have? If they tell you, I'm a permanent resident or I have a permanent visa, great. But you should still be checking if that's real, because there are employer obligations that are under migration law. So even if you are not a sponsor, but you are considering or you are employing someone who is not an Australian citizen, even if they have a permanent visa, you should be checking that that visa is real, because unfortunately, a lot of people lie. I've seen people say, yes, I'm a permanent resident to employers. And then later the employer finds out that they didn't even have a visa. They were in Australia unlawfully. So even if they tell you they have a permanent residence visa, you need to check if that's true. If they are permanent residents, in 99% of the cases, they would have full unconditional work rights. Now, if they tell you they have a temporary visa, which is, as I mentioned before, a visa that has an expiry date attached to it, All temporary visas have one condition or another attached to them, meaning they may not be able to work. For example, a visitor visa, there's a no work condition there, they cannot work, and then you shouldn't be employing them because you are then breaking migration law as an employer. Or if they are on a student visa, they may have restrictions to how much they could work. If they're on a regional temporary visa, that may restrict them to where they could be working. So they apply for a job in Brisbane, but they really shouldn't be working in Brisbane because that's not a regional area. They should be in other cities and towns in Queensland. So you need to check one, does this person have a real visa? Does it exist? And when is it expiring? Plus, what are the work rights attached to that person's visa? Now, how do you check that? The Department of Home Affairs, which is the Department of Immigration, they have a very good online system. You can register as an employer, and it's called Vivo, VEVO, and you can check workers' rights, visa validity. You can check all details about their visas there, when it's expiring, and etc. Um, and you should be keeping records of that. Now, let's say you're employing an international student and that person is studying here for 4 years. You should not just be checking their visa validity and work permission when you hire them. You should really be looking at checking them regularly, especially if they've been with you for a while. Because unfortunately, again, I've seen cases where an employer hires someone on a student visa, they have work rights, everything's great. 6 months later, that person withdraws from a student visa and their courses and applies for a visitor visa just to hang out and continue to work for your business. And you are unaware that that person is breaking the law, they're in breach of their visa conditions. And as a consequence, you as an employer, you are also breaching that, and you are not in compliance with migration law. So best practice is to keep records and check your international workers' visas regularly. Now, we see people in temporary visas here, like I said, working on student visa, working holiday visa, but then as an employer, you can facilitate visas such as the sponsorship visa TSS 482. You can facilitate training visas, which is almost like a trainee position in your business. And you can also nominate workers for the permanent visa. Now, it's always the employer's choice to go ahead with a visa application or not. An individual cannot, force you to go ahead with that. We also have another type of visa, which is a bit tricky for people who are not in migration law, and those are bridging visas. Bridging visa is, as the name says, a bridge between one visa and another. So if someone is here on a student visa and they apply for the sponsorship visa 482, it takes a while for that visa to be approved. If their student visa expires before the department has made a decision on that sponsorship visa application, that person will have a bridging visa that is an electronic grant, and that bridging visa keeps that person legal, lawful in Australia while the department is still processing their visa application. So again, in a number of cases, you may verify your employee's visa and find that they have a bridging visa, and you may not be aware of all the limitations surrounding that bridging visa, and things can start getting a bit complicated because you need to also know, okay, you're on a bridging visa because you're applied for what? They might have applied for a visa that clashes with the type of work that you want them to do. So that's when working with a firm like ours comes in handy, because when we have an ongoing relationship with an employer, it's just a matter of picking up the phone and calling us and saying, Erica, we've got this person here and we're not understanding what visa they hold. We go into the system for you, we check and we explain to you and to that person if there's any limitations. Now, when you become a sponsor, there's even more obligations than when you're just employing a student or a backpacker. There's a whole division of the Migration Act dedicated to sponsorship obligations. They're not very onerous, but there's things such as, again, keeping records, keeping pay slips, ensuring your workers, if they were sponsored, let's say as directors of marketing, that they're not working as receptionists in your office, they've been sponsored as chefs, that they're not working as your kitchen hand, and that they're earning the salary package that was approved, and so on. Nothing out of this world, but again, when you're sponsoring, you should have a migration firm helping you understand and comply with those obligations on an ongoing basis to avoid issues. Now, with a new government comes always new change. Change comes, and it's always a little bit of a minefield for employers to navigate. And again, that's why we're here today. So Labor came into power just over a year ago. Migration is always last in their list of priorities, obviously, and rightfully so. And now, in the past month or so, we've seen a lot of movement in this area. Firstly, the Minister for Immigration, Claire O'Neill, has announced a whole review, pardon me, of the migration program. If you watch the news, if you read our newsletters, we digested that for you into what is important for visas, employers, and employees. But pretty much, this government believes that the whole system is broken. I don't disagree with that. And they want to change everything. Now, changing everything takes a while and sometimes is a mammoth job. So I don't believe we're going to see any changes in terms of how the whole program operates anytime soon. This is something for the next financial year. And by next, I don't mean 2024, I'm talking about 2025. Now, they're talking about reducing the number of visas that people can apply for, simplifying, etc., etc. This has been done in the past, and in a number of cases, it didn't simplify things much. It only made things harder. So hoping that this will not be the case. So from that side, I don't have a lot to report because we don't know what or when they will be doing this. Now, what is important and what has already been announced and what's coming into effect is what we're here to talk to you about. So the first change is that on the 1st of July, international students who at the moment can work unlimited hours will go back to only being allowed to work part-time. So since the 90s, international students have work permission. Australia is one of the few countries in the world where this is offered. A lot of countries, people get student visas, go there to study, and they cannot work. So they can work here legally in Australia. This has been the case for decades. And for the first time ever, last year in January 2022, the government lifted that restriction and allowed international students and their dependents. So if I'm studying and my husband is here with me and he's not a student, both of us were allowed to work unlimited hours. People keep saying, I can work 40 hours a week now. No, you can work 80 hours a week if you want, 60 hours a week. There, at the moment, there's no limitation to where, how many jobs they can have, where they can work, how many hours, including their dependents. Unfortunately, this is going back to kind of what it used to be on the 1st of July. Why did the government do that? Again, when the borders reopened for temporary visa holders. So going back in time, the government closed the borders on the 20th of March 2020. The borders were closed for people who had temporary visas. So obviously, citizens and permanent residents could come to Australia, but anyone else on a visa, visitors, students, sponsorship visa holders, training visa holders, anyone on a temporary visa could not come back unless they could obtain an exemption. And it was very difficult to get exemptions for people. We were working very hard with many people, and it was hard. Not everyone got an exemption. Actually, very few people did. So, what did that do to the labor market? It became again affected by the lack of temporary visa workers holders working out there. So the borders reopened completely um, in February 2022, and for students and backpackers, it opened in December 2021. So we're like, okay, everyone's going to come here now. We're going to have a big influx of workers again, and things were not moving. So then the government said, okay, if you're here already, or if you're arriving as a student, from now on, I think it was around the 20th of January 2022, you can work unlimited hours. So that has been the case. And I know a lot of our employer clients have been really benefited from this because there was a skill shortage out there, especially in hospitality, in construction, in engineering, in the trades. And students working full time were really filling that gap. Unfortunately, on the 1st of July, we're going to go back to part time work. However, there's a little bit of a silver lining there. Before January 2022, when they started this whole work as much as you want thing, students could only work 40 hours a fortnight. So if they had permanent part-time jobs, that would be 20 hours a week. From the 1st of July, that's going up to 48 hours a fortnight. So if they have permanent, not casual jobs, they can work 24 hours a week, which is a little bit better, but not so good. We also have a lot of people out there with full work rights floating around and holding a strange visa called subclass 408 COVID-19 19 visa. So we've always had a subclass 408 visa. That's for people who come here to do sports competitions or performance. So, for example, a band from the US might come here on a 408. Ministers of religion, researchers. There's all these different streams within this visa. When the pandemic hit and the borders closed, the government saw themselves with a problem, being a lot of people were here, their visas were about to expire, and there were no flights out of the country. How do we keep these people in Australia legally without breaking migration law? They created a new stream under the subclass 408 visa and called it COVID-19 pandemic stream. So people started applying for this visa and staying in the country legally. Initially, they didn't have work rights. It was really an emergency visa. With time, the government used this visa for people who had a job offer in what they called critical sectors. So, for example, aged care, health, childcare, and later, people in hospitality and tourism could also apply because hospitality and tourism was added as one of the three critical sectors. Last year, the government, after looking at borders open and still we were not getting a high influx of workers, the government decided to use this visa to keep anyone who already had work permission in the country with full work rights, regardless of the industry they work in, and let them work for another year. So if you apply for, let's say you're on a student visa, or your worker is on a student visa and their visa is about to expire, a lot of them come back to you and say, don't worry, boss, I've got a 408. And you say, how? What is this visa? They show that they were already working and they say, I still have a job offer, and they can get 1 year full work rights. Unfortunately, we believe this visa is going to be seized, as we call when the government kills a visa. This visa might close for applications in July as well. We've been hearing rumors, and it's not in the interest of the government anymore to keep this going, especially if they believe that there might be a job crisis looming out there, which doesn't match the data from what employers, um, you know, uh, um, said in that case recruitment survey, doesn't match the data from what our employer clients tell us, but it might be what they have to do. So if you have international students and you don't want them to go back to working part-time before the 1st of July, um, consider sponsoring them on the 42 visa. If they don't have the minimum skills, experience, or qualification, the training visa may be an option. And if your worker has a lot of work experience, if they have the right qualifications, you may consider a permanent visa via the direct entry. Now, this is not for everyone. It's only for occupations that are in super high demand. There's some IT occupations there, health occupations, construction management, construction project manager, chefs, but in a lot of cases, the person themselves don't meet this. The onus is very high on the applicant. But again, talk to us and we can check your potential nominee and check if they would qualify. Now, big change that's also coming on the 1st of July is the increase of the minimum salary that is applicable for 42 TSS sponsorship visa applications. So when an Australian employer is offering a job to an international worker, there's got to be job offer and a salary package that comes with that job offer. That salary package needs to meet minimum levels. And this is to avoid international workers being exploited. Before this requirement existed, I unfortunately saw many things happening in the news and stories. People being paid $5 an hour because the employer would say, well, you need a visa. I have a job for you. I'll give you a visa, but you need to be my slave going forward. Terrible stories, people living in tiny restaurants where they were working, sleeping on a mattress in the back, earning basic money and being given board and food, and that's not on. So many years ago, the TSMIT, the temporary skilled migration income threshold, was established, and it avoids international workers being exploited. Together with this requirement, there's also a requirement that workers are paid what the market rate is for their occupations, because having a minimum salary is great to avoid, again, that international workers being exploited, but it may affect the salaries of the market out there. At the moment, the minimum salary is 54,000 a year plus super. Let's say someone approaches your business, they're desperate to stay in Australia, and they come to you and say, I'll work for this position, I'll do what is required of me, but I need a visa, I don't want to go back to my home country, and I'm willing to earn less than the market pays just so I can get a visa and stay here. If that happens, a lot of employers will be tempted to say, why am I going to hire an Australian worker if I can get someone for half the price? So to protect Australian salaries, the market rate requirement is also very important. Now, this minimum salary package it used to be amended every year. We used to see a small increase every 1 or maximum 2 years for many years. But for some reason that no one understands, it's been the same for the last 10 years. It's been 53,900 since 2013. So once labor came to power, one of the first things they fixed was to increase the salary to what now they believe is the minimum income someone needs to live here if they're an overseas worker. Now, they have stated that if since 2013 the salary had been annually indexed as it used to or as it should have been, it would be at 70,000 by now. So that's what it's going up on the 1st of July. Now, a lot of our clients are already paying this to workers. The market rate is already up there. So in a lot of cases, employers say to us, how much should I pay this person? And we say, well, the minimum is 54. And employers will say, yeah, but I have other people in the same role earning 80. And then we have to advise employers that if you have any workers, Australian workers in the same position, in the same location, whatever they're earning becomes the market salary rate, and whatever is higher becomes the minimum. Even if the minimum is lower, the TISMIT, employer should be paying what the other employees in the business are earning. If there's no equivalent Australian workers, we have to do salary research. We look at similar positions, we find job ads, we get salary reports. Again, we use the Hayes recruitment guides, salary guide a lot. But in a lot of cases, there's also an applicable award. And as employers, you should be also following the award. So we have clients that, even though the TSMIT hasn't changed in 10 years, they've been paying their employees much more when they sponsor them. Because if an award applies to the Australian workers, that award should be applied to the overseas worker as well. So, excuse me. So we don't believe that this increase will be an issue for a lot of employers, but there are some occupations out there where, the salary package is lower. So let's say teachers of English as a second language in language schools, some sports coaches, and a lot of regional positions. This may be a high salary for a regional position. So what we're looking into is how does this affect your business? You may be tempted, or you may be forced to look at visas where the minimum salary is not applicable. For example, the training visa doesn't require a minimum salary package, but you can't pay anything under what is considered, the minimum for that person to pay for their bills, meet their minimum living needs. So if you nominate someone on a training visa and the salary is very, very low, we might have issues. We will have problems getting that approved. We need to show that that person is earning at least the bare minimum. And sometimes companies offer them food. If it's a restaurant, they can eat in the restaurant. If it's, we have some trade companies that offer accommodation. Sometimes even if they're working off-site in regional areas, that comes with the package, and so on. Now, the permanent employer nomination visa doesn't require minimum salary, doesn't look at the same legislation, doesn't look at the TSMIT. But if your worker is applying for this visa because they have been working with you for a minimum period of time, which is the temporary residence transition stream, you will have to meet whatever they were earning before. You can't nominate them with a lower salary. So whatever they were earning before would be the TSMIT. Now, if we're looking at a direct entry application, then obviously there's no sponsorship visa necessarily on the past, but still we need to look at market salary rates. That's part of the requirement for this visa. So if you have positions available and you want to sponsor people, but you don't believe a $70,000 salary package is applicable, There will be a few options out there, but not many. A lot of employers come to us and say, can I sign an agreement with the department and they would allow me to pay less? So, for example, we just got a visa approved for an apiary in regional Victoria for a beekeeper. And remember, the salary is going up on the 1st of July. So far, we still can lodge and get approvals with salaries below this. And the salary was not 70,000 a year. I'm not going to remember exactly how much it was. I fear what we're going to do next when that business wants to sponsor other workers, because being in a regional area and being, the nature of the job, I don't think it's a $70,000 salary package there. So I'm going to have to work hard with this employer, try to find alternatives. Now, the labor agreement is not a simple thing. It's very complicated, very difficult for a business to enter into one of these agreements with the department. But when and why would a business enter into a labor agreement? When they want exceptions from what the legislation, what migration legislation normally requires. And we're going to look into them closely at the end of this presentation. But one of the exceptions could be salary packages under what the TSMIT is set at. So both these changes are affecting businesses out there. International students going back to only working part-time, and salaries for sponsorship visas going up. Now, another change, sorry, the slides are playing with me. Another change recently, and this is super recent, announced, was that the United Kingdom has been added to the list of countries where you as an employer don't need to conduct labor market testing before you sponsor someone. So if you have sponsored people before, you're certainly heard of labor market testing. You need to advertise the position that you're offering to an overseas worker for at least 28 days in 3 different websites. The ad has to be in a certain format. It's a pain in employers' lives and in our lives. And there's talk that this will be removed with the changes that are coming, but at the moment it's still there. There's always been exemptions, and the exemptions apply when the country where the visa applicants from is a country where we have, Australia has an international trade agreement with. So since labor market testing as it exists came into effect in 2018, we have exceptions for citizens from Japan, China, Thailand, Chile, South Korea, New Zealand, or Singapore. And Mexico is missing from there. We also have exemptions when someone is from Brunei, Myanmar, Cambodia, Indonesia, Laos, Malaysia, Philippines, Thailand, and Vietnam. But only when it's not enough to just be from those countries. Canada is also up there. There's 2 countries missing. I apologize. Mexico and Canada. Now, being from Brunei, Myanmar, Cambodia, Indonesia, Laos, Malaysia, Philippines, and Vietnam on itself is not enough. We need that worker to be transferred from a company in those countries, and they have an associated entity in Australia. When that happens, I don't need to prove to the government, show evidence that the employer has tried to find a local to fill that position, because that's what labor market testing is. I need to show to the government, when you are sponsoring John from the US, that you try to find an Australian to fill that position. And in these cases, when people are from these countries, we don't have to do that. Now, the UK has last week signed a free trade agreement with Australia. I mean, the agreement has been signed a while ago, but last week it has been incorporated into migration legislation to the point that if you're nominating a UK worker, we won't have to um, we won't have to ask you to undergo labor market testing. So if you're from now on, if you are wanting to sponsor a British passport holder, then that person and that position is exempt from having to undertake labor market testing, which is great. It might not seem like a big thing, but it's great. Trust me, because you don't have to wait 28 days, you don't have to post ads, which is a pain for everyone involved. Now, there's also been changes announced in terms of who can apply for a permanent employer visa. So if you have been watching since the beginning, I mentioned earlier that the majority of temporary visa holders in Australia who find a job in their sectors um, and get a visa, such as a training visa, 482 sponsorship visa, 494 regional sponsorship visa, the majority of these workers have an interest, at least, in applying for a permanent visa and staying here for the long term, especially if they're here with their families. Their kids start going to school and they adapt and they start living an Australian life. And then it's very hard to say, okay, my contract with company blah is over. We're all going to go back to where we came from. Um, Yes, that happens. A lot of people come here in secondments, for example, knowing that, that's and expecting that to be a fixed term contract, but a lot of people want to stay longer. And as I said, with the coalition government, the number of people who could stay longer and have an employer facilitate that stay and be nominated by a permanent employer visa, the subclass 186, the number of people who are eligible for that visa is very small at the moment. Only workers who have occupations in a special list called the medium and long-term skills shortage list can come from a 482 visa and apply for a permanent employer visa 186, or skip the 482 visa and apply for subclass 186 directly under the direct entry stream. The government announced, and that was in early May, the government announced that by the end of this year, not financial year, calendar year, so by the end of 2023, all 482 visa holders, regardless of which occupation they're sponsored under, will have a pathway to apply for the 186 visa. This means short-term occupations, so occupations that are not in the medium-term stream or list, will be able to apply for this visa again. And I say again, because when we had the 457 sponsorship visa, this was how it worked. If people were able to get a 457 sponsorship visa, they were able to apply for a permanent employer visa later. The occupation lists for both visas was the same. When they decided to abolish the 457 visa in 2017, and when the visa was eventually abolished in 2018, this change came with the 457 changes, which, as I said before, the 482 visa is just, a different name to a similar visa. But this change was huge back then, and it has been impacting employees and employers alike since March 2018 when it came into effect. We lost a lot of skilled workers in 2018 because, for example, marketing executives, sales executives, a lot of people um, woke up one day and they were here on a sponsorship visa and realized, right, I have a 4 years work visa in this country, and I'm not going to be able to stay here permanently if I want to. What if I want to have kids here? What if my kids are already here in school? Or I have a wife or a husband and they also have a job and we don't want to go back. So these people were like, stuff this. Why are we hanging around? We might as well find a job somewhere else in the country where we're more welcome. So we did see a huge exodus of international workers in 2018. And I think we're losing the race. We're for global talent as a country that needs international talent and skilled people. Since that decision was made, we are losing a lot of um, talent out there. Labor government seems to agree with me because they've always said, they want people to have a permanent residence pathway. We can't have a second tier of citizens that are around in forever temporary visas. When someone's on a 482 visa, they don't have access to Medicare. Just a few countries have an agreement with Australia. Kids don't have access to public schooling in a lot of cases. There's no childcare rebates. People in a lot of cases cannot get a mortgage. So it does create second class citizen, tier to society, and labor doesn't like that. So this should be over by the end of the year. Not only they announced that, but they announced that the moment someone's sponsored and they want to apply for their 186 visa with an employer, which is a requirement, they need to stay with that employer, that same employer, for a minimum of 3 years. When this whole thing changes for subclass 186, it's only going to be 2 years, not 3. So how does this impact your business? One, in the positive side, um, you're going to see more people wanting to apply for jobs. So someone comes on a student visa and says, "Oh, okay, I'm in events and I'm working as a student. I'm working part time. My employer really needs me, and they offered me a full time job and a sponsorship visa." Then they come for a consultation with us or any migration firm and say, "Is this a good visa for me? What happens after X amount of years when I've had this visa?" And then us migration agents have to turn around and say, "Well, after a maximum of 4 years, you have no other visas to apply because there's no permanent visa pathway." And a lot of these people would say, "Why would I even consider getting sponsored? I don't want this." So a lot of people then finish their studies and leave the country. Now it's going to go back to how it was, where people said, "Okay, I probably wasn't even considering staying here for this long, but if there's a permanent residence pathway for me, I'm going to say yes to this job and yes to this sponsorship offer and stay with this employer for a few years and get a permanent visa with them." So your talent pool is going to grow and go back to what it was. Also, when I say short-term occupations, we're talking about roles such as restaurant managers, contracts administrators, some IT technical occupations. Everyone says IT is in demand. Yes, but if you look at developers, software engineers, network engineers, and systems analysts, if you look at hardware technicians, help desk support officers, those guys are not in high demand and they could not get PR later, but now they will again. Fitness center managers, event coordinators, marketing, sales, advertising professionals, and many more, graphic designers, interior designers. So this will hopefully make Australia attractive again for a lot of international talent who may not be considering us otherwise. On another note, this 2 year thing has been creating a bit of a controversy out there. Some of our employer clients are saying, "Great, I only need to sponsor my worker for 2 years. After 2 years, they will approach me and ask me for a permanent visa anyway. So please advise us in terms of how long we should be sponsoring this person." Sometimes 2 years is enough for that worker to get to PR. Sometimes they need more work experience. We might say 3, we might say 4, but it could be a quicker and cheaper process for employers. On the other hand, I have a lot of employers who say, "Well, the sooner my sponsored workers get a permanent visa, the sooner they can leave the job and the company." And I say to employers, "Look, you can't keep anyone in a job anyway, even if they're sponsored, they can change employers. They have 60 days to find another employer and transfer their sponsorship. If they're not happy, they're not going to stay." And we know, especially now, no one stays in the same job forever. So think of the visa as what it is. It's a piece of paper that enables a worker to work for you full time for a certain period of time. Now, that worker will, in most cases, as I said, eventually ask for permanent visa nomination. And a lot of our clients are saying, I know they can apply in 2 years, but I'm going to create an internal policy where, yes, we're going to nominate them, but only in 3 years. I already had clients in the past who said, we're only going to nominate our workers after 4 years because we nominated a few workers in the past years. And as soon as they got PR, they left. So remember, the nomination process is up to you, the employer. It's not up to the employee. You decide if and when your business nominates workers for a permanent visa. I know a lot of businesses out there that don't nominate people at all, especially in the hospitality field. So we have a few clients that are large restaurants, and they poach a lot of chefs from other restaurants where I say, and I was looking at a chef from Canada the other day, and a catering company that's one of our clients. They said, we're going to hire this guy and nominate him for the permanent visa via direct entry. And I was like, okay, let me see if he qualifies. And then when I was checking his information, he was here on a 482. He had been with the same employer for 4 years. His 482 was about to expire. And I said to him, I said, why aren't you getting PR with this restaurant? You've been there with them for so long. He said, they don't nominate anyone for PR. It's their internal policy. They give you sponsorship, the 482 temporary visa, but they can renew it for another 4 years if you want, but they don't nominate for PR. Which I've had conversations with some of our restaurant owner clients where I say, look, can you do that? Yes. Is it a good idea? And I said, no, because it's very easy for you to become, and in Sydney, there's some restaurants where they're known as, restaurants that don't give nomination for PR. And it goes around in the chefing community, and a lot of people don't apply for jobs there anymore. And they don't even, they lose a lot of talent in there. So I say to my clients, if you don't want to give them PR in 2 years, let's develop an internal policy where when you're sponsoring them, at least you're telling them straightforward that, if you want to stay with us, we're going to do it right by you. We're going to give you great working conditions. We will nominate you for PR if you are doing well and we're all happy with each other, but after X years. And that person knows, and they like to know and be told what the policy is. So that's normally what I advise. I don't advise going completely no PR because you lose a lot of good workers. Now, opening up a permanent visa pathway for any occupations will most likely kill the 494 visa. So the 494 visa became a good option for a number of people who had occupations in the short term or the regional occupation list. And if they were sponsored in Sydney, Brisbane, and Melbourne, they could get a 482 visa. They could renew that for another 2 years. And after 4 years, they had no option for PR, for a permanent visa. If, however, they got sponsored outside of those three cities, the rest of the country is considered a regional area for migration purposes. So the whole WA, South Australia, Northern Territory, Tasmania, the ACT, and Queensland, New South Wales, and Victoria, except the three capitals. So a lot of people moved out of those three cities, found a job in their fields, and got the 494 visa. The 494 visa is given to workers for 5 years. And after 3 years working in regional areas, they could apply for a permanent visa without the input of their employer, which is another advantage both for the employee and for you, the employer. Now, if any occupation will be eligible for the 186 permanent employer visa, which is a nationwide visa, so regardless of where their worker is, regardless of their occupation, then and they can apply for PR after 2 years if the employer is okay with nominating them, why will they apply for the 494 and have to wait 3 years mandatorily? So we believe this visa is going to not be a good option anymore. There are some instances then, however, where some occupations are not eligible for the 482, and they probably won't be on the list of the 186 when this legal change comes. Things such as secretary, personal assistant, law clerk, real estate agent. People can only get a 494. They cannot get a 482. And if they cannot get a 482, they can't move to a 186 under the temporary residence transition stream. So if this visa doesn't die completely, it's going to be around there still for people who have these occupations that they cannot get any other visas. But let's wait and see. Now, since we're talking about regional areas, a lot of regional employers have to resort to signing a special agreement with the government. So a labor agreement may be a solution for some employers who want to spend the time and the money in this. Now, it's all about getting exceptions, and the type of exception can vary if your agreement is what we call company specific or industry specific. So let's say I run Bravo Migration and I cannot sponsor law clerks at my law firm because my law firm is based in Sydney. It's not a regional area. And law clerks are only on the list for the visa 494, which is a regional visa. And I can only sponsor people if I had a job offer for them outside of Sydney, Melbourne, and Brisbane. So I say, okay, this is not fair. As an employer, I want to sponsor law clerks. I can't find enough law clerks out there. This is just an example. I approach the Department of Immigration and I try to negotiate company-specific labor agreement where I say, at Bravo Migration, we cannot find enough law clerks in the local market. I will have to support my claim with a ton of evidence. And this will be a negotiation that will go back and forth. Even though it's an agreement for my company, I will have to get the backing of other law firms in my field who may say, yes, it's hard for us as well. And in the majority of cases, companies are not successful in obtaining a company-specific labor agreement. It's much more common to see what is called industry-specific labor agreement. So some industry-specific agreements we have out there apply to the meat industry, on-hire labor, fishing industry, fine dining restaurants. And I tell a lot of my hospitality clients, it's very hard to justify that you cannot get waiters and pastry chefs and sponsor them in the normal visa without a labor agreement. We can't sponsor pastry chefs. We can't sponsor waiter in the normal 482 visa, but to tell the department, my client is a restaurant that they need waiters and they can't get waiters is very hard because we would have again to have a ton of evidence to support that where that restaurant's located, there's no one wanting to work as a waiter. So yeah. Then we have one for the pork industry, the dairy industry, advertising and marketing, which is another funny one, and for ministers of religion who want to work in churches or missions and so on. Now you see here the positions under which they are that are available in a labor agreement. They're not so skilled. So the majority of these positions are not available for a regular 482 sponsorship visa. That's why this industry, this sector, has approached the Department of Home Affairs and said, we can't get enough people to kill cows and sell meat. So they had to prove their case, and this took years until the Department of Immigration said, okay, we agree. There's not enough people working in these positions, even though they cannot normally be sponsored. we're going to create exceptions. So under the meat industry labor agreement, employers can sponsor boners, meat workers, and slaughtermen. Now, butchers can be sponsored. So, are they necessary? Do they need a labor agreement? No. And the same with the others. Again, with the exception of pastry chefs and advertising and marketing people. Now, if you say, okay, this, I want to sponsor a class of occupations that is not usually sponsorable, you could look into your industry and see if there's an agreement. If there isn't, you could get your company to enter into one. But like I said, it's very hard. Another exception is if you say, I don't want to pay $70,000 for a beekeeper, I might have to get all the beekeepers in regional Victoria and try to negotiate a labor agreement with the department. But this is going to take years and it's not a simple process. Now, why am I telling you all this? Because when you see yourself in a position after July where you go, I don't think this occupation attracts such a high salary, 70,000 a year. You may hear people telling you, just go and get an agreement. It's not that simple, okay? Now, the newest agreement in town recently announced is the aged care labor agreement. So finally, we have an agreement. Believe it or not, up until now, it has not been possible for aged care centers, aged care providers, disability providers to sponsor carers, which is shocking. There's a huge shortage. There's a lot of people with the skills out there studying or, wanting to come to Australia and work in these roles, and we did not even have a visa pathway for them. Now there is. They can't be sponsored under this aged care industry labor agreement. There's 3 roles that can be sponsored. And because these roles are lower skill levels, then a lower salary package has been negotiated, 52,000 a year, not 70, which is the new minimum salary. So this is great. Also, the skills required, we're not going to say, okay, you can be sponsored as an aged carer on a 52,000 annual salary package, but you need to have a bachelor in medicine, a PhD in nursing. No, the skills are much lower than what would be required of a someone applying for the 482 visa. Who can apply? People who are here in Australia already. So this has been geared to also recruit international students into the profession who are already here. If they've been working 1 year full-time as carers in Australia or part-time, but then they'll have to work 2 years part-time, they can get into the sponsorship visa under this agreement. Or if they have no work experience, but they completed a minimum certificate 3 in aged care or disabled care or personal care, then they can be sponsored as well. Now, employers will be able to recruit people from overseas as well, but these guys will have to have work experience and study, and they'll have to go through a skills verification process called skills assessment. But finally, we have, a pathway. And not only an occupation that wasn't possible to be sponsored before on the 482 visa is now possible, but it will also lead people into permanent visa. So if you're watching us today live or you're watching this recording and you are in aged care, this could be a great option for you. We're already being flooded with people in and outside of Australia saying, how do I get a job? I want to do this, because it is a shorter than usual pathway for someone to become skilled and then get PR. So that's why, the government was very smart. They made it attractive, not only for employers, but for people to say, okay, I'm going to get a job in aged care because it will have a visa outcome that will be positive for me and faster. All right. So I have been yapping away for an hour and a half almost. Thank you so much for watching me. If you're have been watching for the whole recording, or if you're here live with me, thank you so much for joining us. I hope this has been useful. As I said, please contact us if you're already working with us. Please contact your allocated migration agent if this has brought up questions. If not, get in touch with us via visas@bravomigration.com.au. Send us your questions, and we'll be happy to advise you and help you navigate the skills recession that the country is going through. My name is Erica, and thank you so much for watching.